Good afternoon and welcome to the CCTL book launch on Buddhism and Comparative Constitutional Law, edited by Professors Tom Ginsburg and Benjamin Schonthal, and published by Cambridge University Press in 2023. Here it is. My name is Rehan Abeyratne. I am an associate professor at CUHK Law and chair of our Comparative Constitutional Research Forum. We are co-sponsoring this talk along with the Transnational Legal History Group of CCTL. So it's a terrific book we have today, terrific panel as well. So let me get right to it with an introduction, beginning with the editors. So Tom Ginsburg, who I hope will join us soon online, is the Leo Spitz Distinguished Service Professor of International Law, as well as the Ludwig and Hilda Wolf Research Professor and Professor of Political Science at the University of Chicago. He also directs Chicago's Mali Center for the Study of Institutional and Legal Integrity. Among his many publications are monographs on democracies and international law, published in 2021, and on how to save a constitutional democracy, published in 2018. Benjamin Schonthal, to my immediate left, is a professor of Buddhist studies and Asian religions and the head of the religion program at the University of Otago in New Zealand. He's published widely on the intersection of religion, law, and politics in Asia. His publications include, aside from, of course, this wonderful edited book, a 2016 monograph entitled Buddhism, Politics, and the Limits of Law, which examines Buddhism and constitutionalism in Sri Lanka. We are also pleased to be joined by two excellent discussants. First, next down the line, is my former colleague, Ngoc, who is now a professor of Asian laws at the University of Oxford. Professor Bui contributed a chapter to this volume and has written widely on comparative constitutional law in Asia. His published works include two monographs, most recently Constitutional Change in the Contemporary Socialist World, which was published in 2020. And furthest away from me, last but not least, Professor Douglas Gildow, who's assistant professor in the Cultural and Religious Studies Department here at CUHK. Professor Gildow's research focuses on the intellectual history of modern Buddhism, contemporary Buddhist education and thought, and intersections of Chinese Buddhism and folk religion. Among his many publications and awards, he received a Research Grants Council General Research Fund grant for a project on coming to the terms of modern Chinese Buddhism, 1870 to 1950. So welcome to you all. Thanks so much for doing this. Let me just give a quick rundown of the program before handing over to Ben. So the editors will start with an introduction to the volume. We'll then hear from the two discussants before opening up the floor to questions. So folks in the room, not that many of you, but if you do have a question, raise your hand and a mic will find you, I think. And for folks online, please chat your questions to me via Zoom. To Rehan Abeyratne, and I will ask a selection of those questions to the panel. So with that said, let's get started. Can I hand over to Professor Schonthal?
Great. Thank you, Rehan. Thank you so much, Rehan and Christopher, for organizing this, and to Son and Doug for taking time to come and comment. Tom and I are very grateful. I thought what I'd do, or what might be useful, is to say a few words about how the book came about. And sort of what we saw ourselves as doing and what we're not doing or what we didn't do, and then to maybe lay out what I see as some of the dynamics that we're trying to cover in the chapters. But before I do so, I thought I'd just call attention to the fact that we have here two scholars whose degrees and positions are in Buddhist studies on this podium, and two scholars who are in the law faculty. And it may surprise some of you or not, that until I think this book, this kind of event that brought these sorts of people together was a little bit rare, at least in mainstream constitutional studies or public law studies. That is, it seemed to be that scholars of Buddhism and scholars of constitutional law didn't really talk to each other that much. That in Buddhist studies, we seem to have a preference for older textual things that happen in monasteries rather than parliaments. And in studies of constitutional law, there was also other well-documented biases for normative approaches, perhaps, or for European and American case studies. So the question is kind of, how did we end up here? How did we end up with a setting like this in a book like this? And really here, I think the backstory, the deep backstory, the karmic backstory, if you like, is that Tom and I met when I was a graduate student at the University of Chicago. So while I was doing my PhD in history of religions, I would walk across the Midway and try and take classes at the law school, and met Tom. And really, when we met, I guess that was about 20 years ago, or maybe not that long ago, 2012, 2010, 2011, we talked about the possibility of this kind of book. And we sort of raised the question that, there's a lot of books, or there were at the time, about Islam and constitutional law, about Christianity or the Christian history of public law. But there hadn't been anything sort of comparable for Buddhism. Sun hadn't written his book on Confucian constitutionalism at that time. So we felt like there was a gap there. There was a few articles there was an article by Andrew Harding. There was some work by Richard Whitecross, David Engel, although not in the context of constitutional law. But there was nothing really that was investigating this question of the relationship between Buddhism and constitutional law. And it's a kind of a perplexing thing, or it would seem to be an important thing, because there's fully not a single jurisdiction in what is today South or Southeast and Eastern Asia that at some point in history had not been a major site of Buddhism, and that Buddhism played an influential role on law and political theory in those places. So just as Harold Berman at the time and others had kind of made a case for the historical influences of Christianity on the Western legal system, we wanted to ask questions about the role of Buddhism. And as this book developed, we applied for a National Science Foundation grant, and we started to see this work as part of a larger trend. So Sun's book on Confucian constitutionalism was part of it. Kem Tong, Tansakurong, and Eugenie Muriot, who were writing about Buddhism and constitutional law in Thailand, were making some reflections, and we saw a kind of opportunity to write something broader. So we applied for this NSF grant, and we were hoping to host a seminar, a big interdisciplinary workshop in Chicago. And then, of course, COVID. And so we scuttled our plans from there, and turned what was going to be a Insight event into a series of workshops, online workshops. Over about 3 or 4 months, every couple of weeks, we hosted a workshop on a different kind of area. So there was a workshop on Sri Lanka and Myanmar, a workshop on Thailand, and so on. And through these seminars, which brought together, again, a kind of a miscellany of people from law, historians, people from Asian studies, from religious studies, we discovered this really complex intermeshing of Buddhism and constitutional law. So we kind of heard papers about Buddhist actors, Buddhist monks, etc., that were sort of about their role as agents and subjects of modern constitutions. So their role in agitating for certain things and protections for Buddhism included in the Constitution, their role in constitutional litigation. We saw examples of Buddhist notions of rule of law. So the big question that came out of the workshop was, is there something like Buddhist constitutionalism? Is there a tradition of rule limited by law that comes out of Buddhism? We looked at we looked at examples of Buddhism as an object of constitutional protection. So what were the implications of having special constitutional perquisites for Buddhism in a number of Southern Asian constitutions? We looked at the Constitution as a form that may have been adopted by Buddhists in contemporary and historical settings. So the Constitution is a form adopted by monks in monasteries, having constitutions for a monastery, but also the Constitution is a form for lay Buddhist organizations in Japan. We also looked at the way in which constitutional imaginaries, the idea of having a single law that's both kind of mediates the identity of a population and also sets the sort of guiding rules for that group. That idea being imported into Buddhist settings by various groups, and quickly we realized that there was a real complexity here. That it wasn't just about some kind of polar relationship between two poles, between Buddhism on the one hand and sort of modern national constitutions on the other. But there was this real complexity, this sort of intimacy without, with victors going a lot of different ways. And it's from this that we decided to coin in the introduction this idea of the Buddhist constitutional complex. That is this idea, this idea that communicates the intimacy between Buddhism and constitutional law, constitutional traditions, modern, mainly Western constitutional traditions, without implying that there are two somehow naturally separable things there, acknowledging the fact that they're kind of co-constituted in a lot of cases. So we looked at some chapters, such as those on we have chapters in this book, such as those on Korea, written by Mark Nathan, or Tibet, written by Bertha Jansen and Martin Mills, and one by Christian Lammerts, that show that Buddhist history has its own constitutions and traditions of constitutionalism, or ask the question of whether they do. So there's some chapters that look on that aspect. There's a second, I think, bank of chapters that look at how Buddhist actors and ideas influence modern national constitutions. So there, the case studies we looked at are in Myanmar, in Sri Lanka, and in Thailand. And then thirdly, there are chapters that illustrate how modern constitutions are this kind of set of ideals and textual forms that's influenced the development of Buddhism. So I think one interesting case here is Krishanta Fredericks wrote a really interesting chapter on the way in which the Sri Lankan constitution and its preferential status for Sinhala and its form, the actual form of the constitution itself, has influenced, played an influential role in some new Buddhist groups, or a particular new Buddhist group in Sri Lanka. I may just leave it there, but I just want to end by saying one thing that we didn't do in this book is kind of lay out a normative project for Buddhist constitutions or Buddhist constitutionalism. This is very much a kind of empirical and descriptive book, and we really leave open the question of whether there is such a thing or such as Buddhist constitutionalism and what that would look like. So I may just leave it there.
Terrific. Thank you, Ben. Oh, yeah, thank you, Ben. I guess we can now turn to our discussants. So, San, can I invite you first?
Okay. So how long I will talk?
Up to you, 10 to 15 minutes or so.
Okay. Okay, so thank you, Rehan and Chris, for inviting me to this book launch, and thank you, Tom and Ben, for inviting me to contribute a chapter for this book on Buddhist governing of Buddhism in Vietnam, which is basically about constitutional relevance to Buddhism in Vietnam. So, but in this discussion, I will not talk about my chapter, but I have first 3 remarks on the contribution of this book, and then I turn to 3 comments about this broad approach. I think 3 remarks about the contribution. I think the book make 3 important contributions to methodology, to substantive contents of doing comparative constitutional law, and to the countries we cover in comparative constitutional law studies. First, about the methodology. So Ben, as you have said, comparative constitutional law has been mainly dominated by case studies, like judicial approach, right? So court-centrics dominate our approach. And this book is to move away from that court-centric. So you cover not just litigation, but also constitution making, the role of religion, and also social actors in this one. I think that is significant to continue to move away from court-centric approach in doing comparative constitutional law. The second contribution is about the countries that the book covers. In the field, for example, for many years, our field has been dominated by very familiar, usual settings, liberal settings in Western countries like US and UK, right, or some big Western countries. And even when we turn to Asia, we also tend to focus on very big developed countries, democracies in Asia like China, Japan, Korea, and Taiwan. But with this book expands the scope of the jurisdictions that we cover. You consider different countries, including small countries like Bhutan or even Vietnam, we also cover it, and Sri Lanka we also cover it. So that is, I think, second important to continue to expand the jurisdictions in the scope of doing comparative constitutional law. And the third contribution is substantive. So again, in comparative constitutional law scholarship, we tend to focus on the settings dominated by liberalism, right? So mainly liberal democracies or liberal ideas that underpin or support these institutions. But in this way, you move away from the liberal settings and consider non-communitarian. Buddhism is non-liberal settings. So I think that is another significant. And in my book on Confucian constitutionalism is also an attempt to move away from liberal constitutionalism. And this is another example of what Professor Mark Transnational called pluralizing the concept of constitutionalism beyond the liberal model. So I think these are three important contributions of the book, and it's not coincident because the Tom and then before you wrote this, you edited this book, you already contribute to the expansion of the scope. Tom, then you already wrote several articles and a book about this Buddhist constitutionalism. Tom also edited several books about comparative constitutionalism in Asia, Latin America, Africa. So this is continue your efforts to expand the scope of the scholarship. So this is my remark on the contribution and very welcome contribution of the book. And I have a few comments. 3 comments. First is about the justification of why comparative constitutional law should engage with Buddhism. So as you said, the most important thing of contribution of this book is you situate Buddhism within the mainstream of comparative constitutional law, and the justification is, so how should we justify that? Right. So in the book, you also mention on several reasons, but basically we can develop 2 models of justification. The first model I will call the external model, which is we tend to dominate your justification. We study Buddhism because the eternal reason that Buddhism is significant, right? Because there's some consequence of Buddhism here in the region, constitution making, the influence of Buddhism on constitutional politics. So the reason here is we study the topic because it's consequential, because the eternal outcome of the research, our research, right? So I think this okay. This is a good justification. And there is another model, I think, but it's not prominent in your book, is what I call the internal model of justification of studying Buddhism. By internal model, I refer to Tom's dialogue, the dialogue between Tom and John Halley. Why should we study Japanese law? And Tom wrote an article that we study Japanese law because it's there. Tom, remember, you remember that one. So the internal reason is that we study Buddhism because it's here. It's not because it's significant. It's not because it's some like consequences of Buddhism, but because there is a gap in the knowledge that we need to discover. That is, there's some unknown. Study Buddhism because it's interesting. There's a gap here, and we need to discover that one, right? So I can talk about like 3 kinds of gap knowledge. The first is the textual knowledge. We need to discover Confucian Buddhist text, or the text of the formal constitution that refer to Buddhism. That is one kind of knowledge. The second is what we can call the functional knowledge. the relationship, the actual relationship between Buddhism and constitutional practice that you cover here. And the final knowledge is conceptual knowledge. The concept whether there's something that we can call like Buddhist constitutionalism. This is a conceptual knowledge that we need to discover. And I want to emphasize the idea that we study for this knowledge. If we have the reason for study, for the second reason, we don't need to just focus on the countries that with a domination of Buddhism. Or we don't need to just focus on big countries. Laos, for example, we also need to cover Laos here, right? There's another reason. I think this not because of the significance of the topic, but because of there's some internal justification that we need to produce knowledge. The topic is interesting. We need to discover this knowledge. My second comment is about how should we, as scholars of comparative constitutional law, do research on Buddhist constitutionalism. I understand that the topic is interdisciplinary, and as you said that we invited scholars from different fields: comparative constitutional law, law and religion, law and society, and Buddhist studies. The topic is interdisciplinary. The question is there any distinctive things about doing Buddhism from the perspective of comparative constitutional law, which is different from like law and religions, Buddhist studies? So what are so the title of the book is Buddhism and Comparative Constitutional Law. So what is our approach here? The field of comparative constitutional law approach here? I don't know, but in my chapter, my approach is this. When you invited me to write this chapter, I thought about it. So as a scholar of comparative constitutional law, how can I approach this book, this topic? So my approach is, I situate Buddhism within the global debates in comparative constitutional law. So this is why I begin with the debate on big C constitution, small c constitution, and also Buddhist and religious constitution. So there are three debates in comparative constitutional law scholarship here. So this is in my chapter, I consider the big C mean the formal constitution in Vietnam. They don't explicitly refer to Buddhism, but there are some fundamental principles about the leadership of the Communist Party and the religious freedom, especially the leadership of the Communist Party. They said that the party is the leading force of the society. The society here means Buddhism, including Buddhism. So Buddhism is under the leadership of the Communist Party. And then I turn to scholars in comparative constitutional law called small c constitution, or regulation by the government, like legislation, how legislation regulate Buddhism. So I study the religion law in Vietnam and how that law put Buddhism under the control of the state. And finally, I use your concept on religious constitution. I conceptualize the charter of the Vietnamese Sangha as a kind of Buddhist constitution. And so I consider the parallel between the state constitution and the Buddhist constitution in Vietnam. The feature is that the Buddhist constitution in Vietnam try to replicate the state constitution. They use the same principles in the constitution, including the Lenin principle called democratic centralism as the governing principle for Buddhist government structure. The reason is that why they do that, because when they wrote the Buddhist Sangha, they wrote the document. They are under the control of the government. And I'm sure that the Buddhist constitution has been approved by the state. And this is why the state try to put Buddhist Sangha under that control. So at the same time, the state try to facilitate the development of Buddhism. But and on the other hand, the state try to put Buddhism under state control. So that is my approach in this writing this chapter. My final point is about your also about relevant to your final point about can Buddhist, whether there's something that we can call Buddhist constitutionalism. And I think that can be an empirical and normative protects. I quite like your concepts about Buddhist constitutionalism, but you define Buddhist constitutionalism as an attempt to use the formal constitution to protect the Buddhist teachings, like institutions, right? I think that should be a definition for constitutional Buddhism rather than Buddhist constitutionalism. So in introduction, you also define constitutionalism is something that we try to subordinate the state power under fundamental norm. So I think Buddhist constitutionalism, similar to Confucian constitutionalism, should be something about subordinating the state power under some norms that we can find in Buddhism. So how Buddhist principles control the use of the state power, how Buddhist principles can prevent the abuse of state power. So I think that is Buddhist constitutionalism. So with that definition, we can approach Buddhist constitutionalism from 3 angles. I use the same approach when I did my book on Confucian constitutionalism. One is the ideational approach. We just look at the text of the Buddhist as a philosophy and to see whether there are some constitutional ideas within the Buddhist philosophy. That is classical and ideational approach. In this way, Buddhist constitutionalism is a philosophy. It's not a practice. It's a philosophy. We just discover where there's some ideas about Buddha. And I can see that there's some similar features between Buddhism using moral principle to control the use of the royal power, similar to Confucianism, right? So maybe there's some parallel discussion between Buddhist and Confucian constitutionalism there. The second approach is historical. So we try to discover whether in pre-modern Asia, there was some forms of Buddhist constitutionalism. There's some attempts to institutionalize that ideas. So when we talk about Laos here, some book about Buddhist government in Laos said that in theory, the power of the king is absolute, but in practice, the king was under the limitation of Buddhist principles. So these are some historical form of Buddhist constitutionalism. And the final is contemporary and institutional. So now, this is what the book about. So we try to discover under the contemporary practice how Buddhism contribute to the constitutionalism project. And I want to end this talk by referring to Buddhist Vietnamese Buddhist monk Thich Nhat Hanh theories about engage Buddhism, right? So in this theory, engage Buddhism refer to the idea that's how societies, Buddhist monks or institutions, they use Buddhist teaching to mobilize for something that's very much about constitutionalism, like freedom of speech or religious freedom or human rights. So how Buddhism actually engage in the society. Maybe Buddhist social movement, how they defend some fundamental norms and subject the government to current fundamental norms. So I think that is another approach. I don't call this a normative, but at least we can explore this topic from an empirical perspective. I'm stopping. Thank you.
Great, thank you, Son. So Professor Ginsburg has joined us, so welcome to him. He is going to speak after our second discussant. So Doug, please go ahead.
That's the clicker there.
So hello. So I'm unlike some of the speakers here. I was not directly involved in the book. I was not an editor or an author. And I also do not have a background in legal studies. I study Buddhism, specifically Chinese Buddhism. And so I actually started just reading this book a week ago or so. And so I'm still digesting some of the ideas. And partly for that reason, I need to use the crutch of having some slides here but for those of you who perhaps have also not read the book or are less familiar, this may also be helpful for you. So it's on. There we go. Okay, it's working. Okay, so now Ben made some effort to show that the basic idea of the book is rather complex and multifaceted. There's a Buddhist constitutional complex, I believe, is the underlying theme. At the same time, there do seem to be, as I see it, two central themes, if we want to make it go to the simple road. So, simply speaking, two underlying questions throughout the book, as I saw it, were how does Buddhism shape constitutional law, and how does constitutional law shape Buddhism? Very, very simple. The second question, maybe more specifically, also involves how do legal regimes and political authorities shape the structures and practices of Buddhist institutions? That seems to be, we drill down a little more specifically. It's often that was the second question. And this is an outline of the book with the different sections. There are 6 sections total, including the introduction. And I'm going to talk a bit about the section 4, part 4, on Northern and Northeastern Asia, because as I mentioned, I study Chinese Buddhism, and China is part of this area. These are the 5 chapters in this section. So Japan, Vietnam, China, frontier China / Japan, depending on which period of time, and South Korea. The time frame of this is the early 20th century until the present. And in terms of constitutions or legal regimes, this is my way of kind of dividing it up. I saw a few different ways of dividing these different regimes and legal regimes and states. We could say some are in a colonial context, some were democratic, and some are Leninist. And I saw the similarities between the different types of regimes based on those categories. Also briefly mentioned in the book are North Korea and Taiwan, but they do not have dedicated chapters, just a brief mention. Now, within this section, all the chapters I found very engaging and very much worth reading. I can speak mainly, I guess, to the people in the Buddhist studies community. So I'd encourage you to if you're in that community, to check this book out for modern and contemporary Buddhist history. Now, within this section, I think that chapter 12 is particularly good at connecting with the general themes of the book. Some of the other chapters had other strengths as well, but chapter 12 really hits on some of the central ideas and actually flips some of Ben's ideas in some interesting ways. So I'm going to talk a bit about chapter 12 more than the other chapters. It's called Constitutional Buddhism. We were just talking about Buddhist constitutionalism. And so this chapter talks about constitutional Buddhism. So the author, Levi McLaughlin, just mentions that unlike other Buddhist majority countries, Buddhism has little influence on the law or constitution in Japan. And then he does reveal later, I think rightly, that whether Japan is majority Buddhist is also a matter of some debate. I would say that this statement is actually true for other countries in this region, in this East Asia, North Asia region. Unlike, I think some of the discussion was focusing more on Southeast Asia, South Asia, Himalayan Asia, where Buddhism is stronger in terms of percentage of the population, in terms of links to political power, tradition. In East Asia, it's a important component of society, but it's not strong in the same way it is in Thailand or traditional Tibet. So according to McLaughlin, what you see here is the question to ask is more the second of those two questions. How does constitutional political forms influence Buddhism? Is often more the question than how does Buddhism influence constitutions? And so constitutional Buddhism for him means forms of Buddhism in modernity which are being shaped and which adapt institutionally and ideologically to constitutionalism or to constitutional structures, the political structures in these countries. McLaughlin does furthers this concept through some case studies of how Japanese Buddhists responded to national disasters, and also two Buddhist organizations related to Nichiren Buddhism, a lay Buddhist organization and a political party. And he shows that these institutions and the responses, the Buddhist charity and disaster relief, adhere closely to provisions in Japan's 1947 constitution, which mandates a strict separation between state and religion, a mandate which is also strongly supported in the case of Japan by public opinion. And so as sometimes Buddhists would cross those boundaries, and they were penalized in the court of public opinion, if not directly by legal means. And then over time, they've learned to do disaster relief and charity work, even funerary things, in ways which are increasingly secular, downplay the religious elements, or very respectful. They always ask informed consent for doing Buddhist rituals, this kind of thing. Also, the political party with Buddhist roots has also de-emphasized its Buddhist roots. And yet now, I think the most compelling case in this chapter for me was the Soka Gakkai, which is a lay Buddhist organization, where you see, where in Kometa you see this political party moving away from its Buddhist roots. Here you see a Buddhist organization which is explicitly advocating constitutionalism. It coordinates its own sacred rituals and events and extension of leadership with national political days, the Constitution Day. It enacts its own internal constitution, so it treats the national constitution as almost as a kind of sacred text as well, and copies constitutional procedures for its own internal structure. This is done also in other Buddhist sects or orders. Many of them also have a constitution, and also in the case of Korean Buddhism, as Nathan's chapter shows. So here we see the main point being that Buddhism is becoming constitutionalized rather than constitutionalism being Buddhicized, in short. And yet, and a lot of the chapters had some surprising point or a point which maybe gives us more room for thought. Soka Gakkai's eternal authority structure seems to be increasingly dominated by one former leader, this called in their constitution an eternal mentor, Daisaku Ikeda. And as McLaughlin points out, this harkens back to Japan's earlier 1890 constitution, which enshrined the emperor as this highest source of authority, which defined Japanese people as subjects rather than citizens. So in a way, I think this is not fully answered. Maybe this is a room for more, there's more discussion, but is this a case of charismatic authority being disguised by the rhetoric of this kind of rational legal authority of a constitution? And do Japanese, perhaps some of them, have this kind of emperor-shaped hole, this sacred emperor-shaped hole that they fill with the leaders of the various orders and new religious movements? Okay, so I will go a little more briefly over some of the other chapters. The next two go well together. They both are in Leninist, communist Leninist contexts. One by Son and one by Andrew La Liberté. They show how Buddhist institutions are shaped by the state as well, but in this case, a Leninist political state. Buddhism is, in each case, is represented by a national level organization, which is in some ways corporatist, and that organization is controlled or integrated into some kind of United Front, is called in China, or Fatherland Front in Vietnam. What was interesting for me is that in Vietnam, there seems to be quite an emphasis on reform and religious freedom, which is actually taken seriously and increasingly so. In China, in recent years, this is more the opposite case. The control of religion in the last 10 years or so has become stricter. And in this chapter, the author discusses the Buddhist Association of China, especially in terms of its diplomatic initiatives in the region. And in terms of constitutional law, which is, of course, relatively weak in China, that's not so much an emphasis, the explicit constitutional law, but the author looks at the implications for constitutional law in the region. And the implication seems to be that the CCP tries to use the Buddhist Association of China as a kind of soft power or perhaps sharp power vis-a-vis other Buddhist organizations in other countries, and it tends to do more so with non-liberal, non-constitutionalist states. So it may be even undermining constitutionalism, as understood as a limitation on state power. So in both cases, Buddhist institutions seem to be becoming more Leninist over time, at least in China. I'm not sure for Vietnam. And even as Son mentioned, even the internal rhetoric of these Buddhist institutions, they sometimes talk about democratic centralism as a guiding principle. Actually, La Liberté didn't mention that, but I've actually seen it in some of my own readings of these Buddhist associations in China. They say, yeah, we are run on the principle of democratic centralism. I have a brief question, I guess, since this is my area of specialty. I wonder, this might be a question for La Liberté or for all of us. La Liberté presents the Buddhist Association of China as a kind of free agent with, obviously controlled under some control of the Communist Party, but still kind of its own agent. I wonder in the last 5 or 10 years to what extent it's actually even more of a tool, in the sense that there's some evidence that it actually has a CCP cell within it at the national level. And so is it in fact even internally being now run by party? The Secretary General is also generally a party member. So to what extent is it even kind of a semi-independent, or to what extent is it literally more an arm of the party? Okay, so the next 2 chapters, I think in the interest of time, I'll go a little faster, but they're also very much worth reading. One is on Inner Mongolia under 3 different political states as a colonial area of 3 different states, the Republic of China and 2 different Japanese puppet states. And the final one has a lot of connections, I think, with the first chapter discussed. We're in South Korea, Buddhism in South Korea, where you do have more democratic constitutionalism, how various Buddhist orders are adapting to that legal environment, partly by making their own constitutions and litigating through courts. Okay, so in conclusion, this section, and of course, this is only one section of this 6 sections in the book, but in this section, there's more emphasis on how Buddhism is shaped by constitutional regimes. And we see how Buddhist institutions have been shaped and are continued to be shaped to partly resemble state institutions. To use some terms from sociology, we can say they're undergoing institutional isomorphism, and there's different kinds of that in that theory: coercive, mimetic, and normative isomorphism, which might be worth more exploration. Some other further questions this brought out for me was, can we see this as a case, and in what sense can we see this as a case of even broader themes of modernization or secularization of religion? Maybe resonating with Son's interests, what contributions could or might Buddhism make to constitutionalism in the sense of actual limitations on state power? What what contributions could be made. This would be a normative project, perhaps in part best done by Buddhists and Buddhist institutions themselves, if they're be interested in pursuing that, perhaps in justifying constitutionalism and through different modes. And the third, maybe more case studies. Taiwan is a country with relatively strong constitutionalism and strong Buddhism relative to the PRC. So there might be some interesting studies which could be done there. There could be more research on these internal constitutions of Buddhist orders, and then the whole issue of the rhetoric versus the reality of constitutionalism in Buddhism. And this is a closing thought is just will the rhetoric, is sometimes what might be rhetoric, will that eventually become more the reality? I was thinking in the case of Japan, when the great charismatic leader who promotes constitutionalism, but maybe he really controls it. But when there is the great leader and people are left with these legal instruments, will that somehow become even more the reality? So those are some closing thoughts. Thank you for your interest and attention.
Great, thank you very much. Both of you, really interesting, I think, and rich comments. Let me now hand over to Professor Tom Ginsburg for any responses to those comments or anything else you'd like to say. Tom, over to you.
Excellent. First, let me apologize. Miscalculated the time. Not uncommon for me, but this was egregious. So sorry, I missed Ben's opening comments. And so maybe some of the things I will say will repeat what he said. But also thank you to Shun and to Doug and, of course, Rehan for contributing your thoughts and taking the time to offer them today. It's clearly, the more I think about this project, which was really an inductive one, Ben might have said this at the beginning, we weren't coming with a grand theory. We're kind of trying to see how what's undoubtedly this very important social, institution, transnational entity called Buddhism, how it would interact with, the modern nation state in the constitutional form. So, inductive work means you kind of see what's out there and then you try to construct something. And in a way, it reminds me of just the recursive nature of scholarship, because every time I hear people talk about the book, I realize, wow, we really need a second volume. We really need to do much more. And there's so much more work to do in each of the areas, and Shun and Doug have highlighted some of those. We need much more work on constitutional Buddhism, as Doug was just talking about, like how these forms have been instantiated into religious institutions, how they interact with the broader constitutional environment, but also much more on Buddhist constitutionalism and what that might be. And of course, I'm sure Ben said at the outset, we weren't trying to do a normative project. Being socio-legal means taking the phenomenon as it is and not trying to say that, Buddhist constitutionalism is a good thing, or a bad thing. It obviously does offer some resources for constraint of state power. It offers some resources for theories of human rights, but it also empirically offers resources for the consolidation of monarchic conservative power, as in Thailand. It offers resources for acts of violence fomented by monks trying to preserve, a kind of vision of a narrow, ethnically oriented, constitutional structure in which Buddhism is the central player. So it's not good or bad. That's the key thing about the socio-legal approach. In thinking about this, though, I do think I want to pick up on something Shun said about, maybe this is like Confucian constitutionalism. We can reconstruct, and he has done great work, obviously, reconstructing what Confucian resources would be available for a theory of constraint of state power. And in some sense, I actually think, even though the Buddhist language is very clear about this because of the two wheels, the wheel of Dharma, the wheel of power, there's always this idea that the wheel of power must be aligned and turning the wheel of Dharma. In some sense, it's supposed to be the, protector, the agent to advance, a kind of advance the sasana, in some sense, the Dharma. And in Confucian, and so there's a very clear sense of constraint on power, and Confucianism has that too. But what Confucianism has that Buddhism doesn't is an idea of an institutionalized constraint. That is, you have the scholars who really do have the duty of remonstrance, and yeah, well, they didn't really do it very much, but there actually is a resource to kind of reconstruct. And so Daniel Bell and others have thought about how we might create a truly Confucian constitutional order, and Sun Yat-sen obviously also. But in Buddhism, from what we just don't know very much, but it doesn't seem like the Sangha was doing a lot of this work necessarily. It's hard to know how those constraints were actually institutionalized. And if not, then they were just internalized. They were supposed to be internalized by the rulers, and that's always good if you get the right rulers. So this is something where we just don't know very much, was my conclusion from the book. But at least at an ideal level, you do have some resources for a kind of normative Buddhist constitutionalism. So I thought that's an interesting thing that both of you raised. It's also interesting to me that we have all these Buddhist societies, and we didn't include Taiwan. We probably should have, because there's a lot of Buddhist activity on Taiwan, and there's a lot of it's possibly a majority Buddhist society, depending how you count. Everything's a little weird with Chinese religion, but we counted 7 majority Buddhist societies, and we didn't include Taiwan. We studied all of them except for Laos, just because we couldn't find anyone to write on it, and Shun was already taken writing on Vietnam. And so we missed Laos. That's okay. I think Laos is a very interesting study. It'd be great to study that. In the communist, context, how the different communist countries, comparative, Leninist Buddhist constitutional complex, we have 3 societies there, which would be interesting to understand. But so we missed Laos. But the point I wanted to make is that it's rather interesting to me that Buddhism is thriving the most in the societies which are liberal democracies, actually. That is Mongolia and Taiwan. You really see very rich Buddhist activity going on the ground, which makes me wonder if actually a Buddhist constitutionalism would be a bad thing, because it would be like other forms of religious constitutionalism, Islamic constitutionalism, etc., might end up being regressive, being captured by regressive forces. Still, at a normative level, I think that's definitely where we have to do much more work. But I find it rather interesting that liberal democracy seems to be the good thing. And Ben and I are actually working on an article in which we're exploring why it is that the Buddhist Sangha in Southeast Asia is so rarely, it has not, unlike other religious faiths, institutions, contributed at all really to democratization movements. If you think about the Catholic Church in South Korea or the Philippines, or you think about the Wahid Gusdur's movement in Indonesia, there really was a lot of role for religion in moments of democratization. We don't see that with Buddhism. So that there might be a sort of small c conservatism there that we're exploring. But all that being said, so I guess the puzzle I'll leave you with is, maybe if we really want to advance a Buddhist vision for renewing society, as Sulak Sivarak has written about, maybe what we ought to do is be promoting liberal democracy, because that's the context in which Buddhist ideas can flourish the most, where practice can spread, and in which the confounding problem, Buddhism of religion and its relation with state power, we can avoid that. I'll make one last comment about China, because Doug raised it. Obviously, the BAC must have a CCP cell. Every institution in China does. The role of those cells, though, is itself a very interesting thing. It's not, we tend to think, especially if we're coming from a liberal democratic perspective, like, wow, these are, mechanisms of controlling everything. And they are mechanisms of control, but there are also mechanisms by which each institution can advance its role within the party state, because it has a channel of communicating within the party state. So that those cells, those officers, which every Chinese institution has, the secretary, Communist Party secretary of the institution, actually can be really important if you have, and really helpful for advancing the role of the institution. So I think it's a great empirical question. How does that actually work in the Buddhist Association of China? I have one other question about the Buddhist Association of China, which I can't answer, but it is the one place where you do have, the Theravada, the Mahayana, the Vajrayana, all represented. And it's another question which we'd love to know more about for a second volume, which is, how did the ideas about state power and Buddhism interact across these great traditions. We really did see different patterns in each of them, different theories of the state in each of them, but maybe there's some interaction there, which would be very interesting to learn about and explore. So with that, I will stop and turn it back to you, Rehan.
Great, thanks very much, Tom. Ben, would you like to say anything in response?
Wow, there's just so many great questions. Hi, Tom. Thanks. Excellent comments as well. And thank you both, Sun and Doug, for really, really thought-provoking questions. I have a whole bunch written down. The one there's I think two. There's I think two that I really want to kind of drill down on. And shouldn't we have this question, why should comparative constitutional law engage with Buddhism? It really sort of hit me quite dramatically, that question. And then, of course, that question provoked for me, why should people in Buddhist studies engage with constitutional law? And there's a way in which I think those questions are maybe not as opposed as we would think. I mean, I think one of the things that we're all trying to do here, I think, at this table, is to globalize the study of comparative constitutional law, to take into consideration historical traditions, philosophical traditions, institutional cultures and whatnot that don't have the kind of Eurocentric liberal norm as their baseline, right? And I think that so in one kind of very basic way, that is one of the reasons, which is a reason that we all share in some of the work we do, why Buddhism is important, right? Because it's kind of there's I love the Christianity-shaped hole in constitutional theory, or a religion-shaped hole that Buddhism, I think in a very superficial way might be. We might hypothesize that it might replace that, right? So I think in a kind of a superficial way, there's this world religions model that Tom and I are playing with here, and we're saying, look, Buddhism is not represented. But then in a less superficial way, I think what's interesting about that is the way in which Buddhism doesn't fit the whole the same way, and that there are different friction points, different institutional imaginaries, different kind of core ideals that are animating what we might call Buddhist constitutional culture, if you like, or early, Buddhist constitutional thinking that we wouldn't see or we wouldn't expect if we were, starting with the liberal Eurocentric Christian prototype. And it's like one sort of very basic example of this is, although we don't reflect on it much in the book because it wouldn't have been good for the title, there really is no word for Buddhism in the before the modern period, right? I mean, so there's Dhamma, there's Sasana, even this in Sinhala Buddhagama is a neologism, right? I mean, it's a kind of a back translation from Buddhism. But there's all these other words that have different implications for the relationship between religion and state, and the sort of kind of legal cultures that or forms that propose some kind of interaction between a dominant dispensation and a political work, right? And it's different in Buddhism, right? So there's different ways of imagining separation as such, right? So we have Chos and Shrid in the Tibetan tradition, or we have this two wheels sort of idea, say, in the Theravada tradition. So I think that's maybe one of the ways to answer Sun's provocation. But then there's this other counter provocation. Right? Why should us Buddhists, Doug, Buddhist studies people care about constitutional law? And I think, that's where I think Doug's questions really, really were generative for me. In particular, and I'm very grateful for you doing this, pointing out, and it's a symmetry that I hadn't really been as aware of as you made clear here. Between the Northern and Eastern Asian cases, in which we have strong examples of constitutionalized Buddhism, right? Where a certain an institutional form, a legal form, has affected the way in which major organizations of Buddhism are imagining and organizing themselves. And that, for me, I think, and I think we see this in a lot of places. And This is certainly true of the monastic groups I study in Sri Lanka. This is certainly true of a lot of new Buddhist movements, non-monastic movements as well. That, whether or not we like it, the modern kind of liberal constitution is the sort of the prototype of legality in the modern world. And Buddhist groups, like a lot of other institutional groups, are subjects of this. And I love the institutional isomorphism, right? And Levy's writes about that a lot in his book too. I think the implications of that are quite profound in Buddhism. And I think that, we as Buddhist studies people kind of ignore, if we're looking at contemporary Buddhism particularly, ignore that at our peril, that these organizations, these actors are being remade in the image of modern constitutional imaginaries. But they're also extremely influential actors in the constitutional projects, not always liberal actors, as Tom said. I mean, often actors what we might call illiberal in certain cases, but they are extremely influential actors in contemporary constitutional politics as well. And I think that the one of the reasons that we haven't engaged with it as much in Buddhist studies is because of the way we've idealized our own discipline over time, and that we have put a kind of certain boundaries in there that we needn't. So those are I think the two questions. I think they sort of speak nicely to each other from opposite ways. There's a ton more, but I'll just stop there.
Terrific, thank you. So now we're open for questions and answers. If folks have questions, please feel free. Let me know. Yes.
So I have. Great, thank you. Thank you for the great conversation. And I haven't read the book, but I look forward to it. So I would like to ask, I guess, our three speakers who were involved in making the book, my two favorite questions for book authors. So question number one is, what was the biggest risk that you took in putting this book together? And why did you decide to take it? Question number two is, was there a particular moment, conversation, document, text that you encountered that fundamentally changed the way you thought about the theme of the book? And can you tell us a little bit about that?
Perfect, thank you. Any other questions coming in? You guys want to go ahead and answer? I think we can wait for some more questions.
Maybe let Tom go there.
Tom.
It was a great question. What's the greatest risk? Well, in some sense, we didn't think there was that much risk because this was such an uncharted field. And we knew that there would be, we knew a lot of individual scholars were working on their individual countries. I guess the risk would be that if we thought that in the end, we couldn't say anything more general than that, that is the inductive project just generated 12 or 15, rather distinct stories in which it was impossible to put together some threads. And so we thought that was a risk worth taking. And I think we hope you'll find when you download the book, because it's available for free, it's open access. So we encourage everyone to download copies and give them to all your friends, give the URL to all your friends. But when you look at it, you'll judge whether or not that was successful. For us, it was certainly successful in generating a massive number of questions. So, Ben and I have a bit of a joint agenda here, and, I'm sure we could pursue it for a long time. And so from our point of view, the risk was worth taking and the risk paid off. Ben, maybe I'll turn it back to you and you can answer about the moment.
Yeah, thank you. That's really good questions. I'm not sure. I can't think of, there's a number of moments in the workshop where I second guessed or I had strong emotions to say. And I'll just name two of them, and then I'll name them in this order because I want the second one to open up onto some comparative questions with Confucian and constitutionalism. One was when one of the contributors, Winnie Sullivan, just raised the issue of, are we not just kind of reinscribing the old world religions thing here and just replacing, Islam with Buddhism? And was there something kind of crass and simplistic about that? And of course, in religious studies, we're all trying to move away from big world religions categories and talk about lived religion and lots of different types of Buddhisms. And were we inadvertently kind of reifying and homogenizing what is, a very complex tradition and arguably, not representing the lived Buddhisms. And that for me was a moment because, I respect and really like Winnie as a scholar, and I really take that critique seriously. And I think one of the things that I kind of realized there then in looking at the case studies was, if we were doing that, and we're doing it alongside a lot of other actors in the world, right? Like almost everyone that we look at in these chapters in the modern context, they do the same act of kind of homogenizing and reifying and grouping together Buddhism as a singular unity that can be protected and, has a lot of qualities of a legal corporation, if you like. And so there's something for me about that I don't know what to do with that in a way. I mean, there's a way in which, that is also a dynamic at play, I think. And I think a dynamic that's very much at play when you look at religion and constitutional law, because at some, there's some moment of where the rubber meets the road in, say, litigation where, Buddhism has to be defined or, like things have to be classified. And there's a way in which, I think there's something about this study and the study of law and religion generally that provokes that question. So I think that was a kind of an anxious moment for me. The other moments for me were when we were looking at things and the symmetry with like contemporary sort of Western legal categories was so enticing that I didn't know what to do with that. If we look at, say, the groupings of what we would want to call or approximate as religious and secular, in these traditions, well, you don't want to map those terms onto those emic terms, and these sort of etic terms onto the emic terms, because there are slight differences, but nevertheless, it's quite enticingly similar. And that's happened. We're working on another book right now about the monastic legal system in Sri Lanka, and I see it constantly. There's things that are like very much, well, there's words that even in the in Vinaya, like early polytexts, are like plaintiff and defendant, right? And litigation, maybe litigation is the way to put it in. The thing, judge, say. So what do we do with that? Like, as historians, we want to say, no, it's not that. But on the other hand, is there some kind of trans-historical, trans-regional, legal imagine? Are there certain kind of archetypes of law that are like, transcultural? I don't know. So this leads me into the second question that I have. I was saying this today. I reread his book in anticipation for today, and when we think about, say, natural law and positive law, or Dhamma and royal law, and there's words for royal law, and the words for royal law have this idea of command very much, or rule of li and rule of law. There's a lot of symmetrical stuff there, right? They're not the same, and then there's lots of ways we would untangle these. But I guess one question I'd like to provoke to all of us here is, it's very unfashionable to say there's some kind of human legal imaginary. But what should we do as scholars with that enticement, I guess?
Great. So I don't see any more questions in the chat. So maybe I can pose a question.
Yes.
Use my chair's prerogative. So I'm going to come at this very much from the point of view of someone who studies constitutionalism and constitutional law in Asia, and someone who doesn't know much about Buddhism. But I think the standard view that I think many of us have, that sort of Buddhism, is at least as it's been sort of understood in a very sort of lay perspective, is pretty benign, at least as far as religions go. But like any belief system, right, it can be kind of repurposed politically for ethno-nationalist ends, as of course we know in Sri Lanka or in Burma. And so I think there's a view, I would even call this the conventional view among constitutional scholars, that ethno-nationalism is the problem, right? And then that does most of the explanatory work in diagnosing what went wrong from a liberal constitutional perspective. And you can kind of fill in religion here. It's Hinduism in India, it's Buddhism in Sri Lanka, it's Islam in other places. And one of the really interesting aspects of this volume to me is to show that actually Buddhism isn't necessarily benign at all. But actually the ideas of Buddhism make a difference in these debates. So I thought this really came through in Kemtong's chapter on Thailand. which, I've read quite a lot about Thailand, but I'd never thought of it in this way. And so he basically makes the argument that certain Buddhist principles sort of foster cultural conditions that legitimate a kind of aristocratic authoritarian style of governance, right? So this includes Dhammaraja, the idea that like the king must be virtuous because he's accumulated all this good karma over many lifetimes, or the concept of Barami, which I wasn't even familiar with until I read his chapter, right? That sort of the ruler has morals of perfection. So I guess I have a couple of questions about this. The first goes off with something Tom said, which is if there are these kind of core Buddhist ideas, ones that actually relate to governance, kind of push in this direction of, shall we say, kind of elite authoritarianism. What does that mean for our conception of Buddhist constitutionalism, right? Because even your conception, which I really like that you get past liberal constitutionalism, but still if it's constitutionalism, there is an idea of limited government under some kind of higher law. And so what are those limits? So Tom was talking about those being internalized by the ruler, but that seems really inadequate, right? Because that just means like, that's sort of the Singaporean, hey, we have Lee Kuan Yew and that's all we need, right? We just need somebody good. So can we say something more about that? Are there some Buddhist principles that maybe push back against that? And is it just a matter of picking and choosing, or is there something there that actually constrains power? And then relatedly, and this goes to something you said, Ben, I'm curious to know what's sort of specific about Buddhist constitutionalism in practice that's different from, say, Hindu or Islamic constitutionalism, right? So I think the comparative chapters at the end of the book, which are terrific, by the way. I only read Deepa Das Acevedo and Clark Lombardi chapter, but I thought they were really, really interesting and generative. But they make the point that there are a lot of similarities between Buddhist and Hindu constitutionalism on the one hand, and then Clark Lombardi talks about Buddhist and Islamic constitutionalism. So I'd be curious to hear from your perspective what's distinctive. So yes, there are all these similarities between sort of these, these major Asian religions and constitutionalism. But what would you say is sort of distinctive about Buddhist constitutionalism?
Tom, do you want to have a...
Well, my answer is somewhat what I gave before. It's in the institutional difference. It's how these, ideas get institutionalized. And of course, within Buddhism, that's quite distinct, even within just say the Theravada countries. But to me, maybe because I'm an institutional scholar, I think that's the interesting angle. So that would be my only answer, actually. So I'll pass back to you, Ben.
Yeah. I mean, I would say, in terms of taking the questions in the reverse order, talking about these differences first. I mean, there's a lot that's of course similar. The institution of the monks, the Sangha, is I think unique. And Clark and us had a lot of conversations about how it was quite different from the Ulama. And I can't think of another class of clerics that has quite the same status when you think about forms of the interaction of religion and constitutional law. So if we think about monasticism and Christianity, certainly it doesn't have that. It's not the kind of embodiment and charged with sort of perpetuating the tradition and standing as an unbroken chain and all the rest of it. So there's this element. I mean, there's this genealogical element of sort of charismatic genealogy that is part of Buddhism that we don't really talk about much, actually. I think in Buddhist studies, certainly in Theravada, it's quite striking, right? So the idea that there's an unbroken chain, which all these people are sons of the Buddha in an ordination lineage, is very much profound. So that is, there's a kind of consanguinity, a nation-like imagination, right, about the Sangha and that manifests in all kinds of ways. It used to be historically, and it's in some cases, it actually, I've heard it said in Sri Lanka that Rajapakshas are part of this, that the leaders, the rulers, were also consanguineous with the Buddha in that they were descendants of the lineage of the Sakya people, right? So there was a kind of, very real linkages by blood in this religion that are part of it. The other thing that's really distinctive, I think, is the idea that the sasana, the dispensation of the Buddha, the utterances of the Buddha, the Buddha's legacy, material and philosophical legacy in the world, is like everything in the world, impermanent. And therefore it will eventually pass away, and that it's the leader's role to preserve this fragile thing. right? So that's, again, very strong in the Theravada tradition. I think those things are a little bit different than, say, Hinduism or some constitutional. It's interesting. I mean, I think I would be curious what some said about if there are similarities with Confucian constitutionalism in the sense that the institution of the scholars and the kind of the importance of upholding Li for the purposes or the purposes of for the good of the people, and there being a kind of a legacy of the mandate of heaven kind of thing, in the same way that protecting the sasana has a kind of a legacy quality to it. So that's one question I would ask him. The other question is about in this, and then there's another question which comes from your question about actual constraints on power. So in rereading Sun's book, one thing that was very striking to me is that in both Hinduism and Confucianism, you have norms that suggest that rulers should behave by certain kind of ethical, in certain ethical ways, or should be constrained by certain behavioral injunctions, right? Don't be corrupt. Don't govern in anger, and so on. But at least in the Confucian case, you have, and we were talking about this before we started, like a pretty solidly agreed upon canon of written texts that people can go to. They can debate what those things mean, but there is a kind of there seem to be very clear bright line boundaries around what is considered, constitutional in terms of the sort of written constitution of that kind of system. In Buddhism, I would suggest that these constraints, I mean, one of the reasons that these constraints on power can be so wavy is that there is not that same agreement on a written set of texts, right? Now, this has not always been the case. So in pre-modern mainland Southeast Asia, there was this idea that the Dharma was like quite literally written in letters the size of cows on the boundary wall of the universe, right? So there is a idea that there is a written law out there, and that can be manifested in different ways. But in the contemporary period, we could offer opposing suttas, say, or opposing sources, opposing versions of Vinaya to argue. We couldn't even agree on what the constraining texts are themselves, right? So I actually want to ask, if I may, Sun, put you on the spot, just those two questions of you, which is to say, would you say that Confucian constitutionalism has this institution that's similar to the kind of monks and this idea of the sasana in Buddhism, and also that actually there is this core group of constraining texts that is as sort of agreed upon as I'm imagining?
Yeah. So Confucianism. Yeah, this is different. It's like Confucianism. They have some core texts like the 4 books and the 5 classes. So that is the difference. But the thing is that the interpretation of the text is quite different. Comparing like classical Confucianism, Han Confucianism, New Confucianism, and New Confucianism.
Right.
So the way they interpret the norm is quite different.
Right.
For example, in classical Confucianism, there are 5 relationships, and the relationships are mutual.
Yeah.
But in New Confucianism, there's still the relationship there, but just one way, submission.
Yeah.
Like for example, in classical one, the relationship between the king and the subjects, if you're good, you behave good, you support you work for the happiness of the subjects, the people. The people will support you. But if you fail, people can make revolution. Like Mengsu's idea of Minban, right? But you don't have that interpretation in New Confucianism.
Right.
Just one way submission of the people
Right.
to the absolute king.
Right.
So
Right.
to the king. So this,
Right.
of course, they have some core text, but the interpretation is different. A good thing about the unified text is that sometimes the text function, the Confucian text function is like a constitution.
Yeah.
Scholars, they use the text to discipline the king. So that is another good thing about another different thing about Confucianism compared with Buddhism. About the institution, yeah, I agree that Confucian constitutionalism is more institutionalized. But Confucian philosophy is it's not very much institutionalized. Confucians, the classical Confucians, they just talk about some moral principle to limit the king powers. But later, historical development of the empirical government, they created institutions.
Yeah.
These institutions, including scholars' institutions to discipline the king's power, they are the institutional embodiment of classical Confucian constitutionalism.
Yeah.
So that is the difference. But the thing is this, different from Buddhism, Confucianism itself is not institutionalized. We have some Confucius temple, but we don't have the Sangha in Confucian as a tradition or as a philosophy, right? So maybe that is another difference. But maybe the internal institutionalization of Buddhism may have an effect on the way that Buddhism influenced the state power. Maybe in terms of institution, I think we should consider this dimension. And again, but my another point is that if we approach Buddhist constitutionalism, Buddhist constitution as a normative project, I think we should consider Buddhism as a philosophy first, rather than just a religion. But there's some debate. But in this way, we consider Buddhism as a system of normative norms, to consider that whether there's some ideas about Confucian, about constitutionalism there. Finally, there's Newtonian social movement and social constitutionalism. In this way, we move away from the institutional approach. It's not very much about the institutional constraint, but how social actors constrain state power. In this way, we consider Sangha as a social actor. Like Buddhist activism in Myanmar, for example, is also quite active. And I give you, even within Vietnam, Buddhist activism is not strong, but during the debate on making the new constitution in 2013, Buddhist monks, they also engage in the debate. And the main focus is on protecting religious freedom. The churches say that the state should protect religious freedom. And they give talk in the public spheres to comment on the new constitution. This is kind of public debate on constitutional questions and consider how in countries with prevalence of Buddhist population, how the Buddhist monks engage in public debate on constitutional questions. I think that is another question to consider.
Any final comments? You have about 2 minutes left. Tom, you look like you want to say something. No, okay.
Can I ask a quick question on Belgrade?
Sure.
So one thing that's come up in these conversations that we've had about this book, when we've talked about it in the context of East Asian places, Singapore, for example, is that Mahayana versions of Buddhism tend to be less centralized and have a less centralized imaginary, generally speaking, which is of course interesting, right? Because you at the very same places, you have like a kind of the Buddhist, like the BAC and other things that are kind of centralizing. So what within your work, is there a kind of a central imagined kind of a unitary imaginary, say, among Buddhists in China, that they imagine themselves as part of a single thing and unified together, the kind of state architecture notwithstanding? Or is that, I mean, because in Theravada, absolutely that's the case, right?
So, well, I guess the 3 new terms, which Tom actually mentioned, seem to be prominent, and a lot of Chinese want to build them up. Like this is what is the 3 forms of Buddhism, the 3 traditions. So Hanchuan, the ethnic Chinese Buddhism, that's a relatively new term that people want to promote. And there should be Hanchuan Buddhism should be a powerful actor on the international stage. Why are we behind Japanese Buddhism or Tibetan Buddhism? So, and then there's also the Tibetan Buddhism and the Theravada Buddhism in China. But the majority of Chinese, of course, are Han. So that's like a new maybe link to some kind of cultural nationalism and this. So that's the first thing that comes to mind.
So the Unitarianness is around Han.
Yeah, and well, there's different definitions even of Pantra. It can even include Japanese and Korean Buddhism because their scriptures are in Chinese, which the Chinese like to remind. Right. And Vietnam, I guess, too. So, and then there's a broad and a narrow definition of that Han Buddhism.